Just second part 2.
Well, it's paragraph 2. Leave is granted to the respondent number 5 to file a supplementary affidavit in opposition to the petitioner's application. Supplementary affidavit to be filed. Such supplementary affidavit to be filed on source. Well, I would believe this would be the objection to the
affidavit that you will file.
Why would we file another supplementary affidavit?
Oh yes, we get it now. You were given permission to file supplementary affidavit. You filed that.
No, my lord.
When are you going to file it?
Rejoinder, my lord, in that, my lord.
No, this order is there. This is a judicial order.
My lord, can you see the last part, rejoinder, if any is there?
No, see, first is you are granted to file supplementary affidavit, and they are permitted to file an affidavit in opposition to your supplementary affidavit, which is to be filed. Correct. And after you file something to be filed, you're allowed to file the rejoinder to that. That's what the order.
Would be a rejoinder and then a sir rejoinder to that, Malaj.
I think. Can we simplify it?
I would pray, Malaj, that require some simplification.
We just record that the applicant's counsel for the applicant, Mr. K. Paul, senior counsel, submitted that to simplify matters, they may be permitted to file a supplementary affidavit, to which rejoinder may be allowed to the objectors. That's respond number 5. That list after 2 weeks.
2 weeks. I'll oblige.
Hearing item number 2.
Maybe the roster might change. See, Dr. Mojika, since these attack matters, the roster might change. So I think we better post it some other day. So this matters have to be streamlined also.
Right.
You agree with that, Mr. Sau?
Yes,
Yes, when?
the next week, 2 weeks.
Yes, on the preliminary counsel with the parties, this is a matter of 2 weeks.
Yes.
Any mention?
I please, Your Lordship. Lordship, I beg to mention item 29, Lordship. Learned
29?
seniors, 29, Lordship.
Sabong, you have an objection? Okay, yes.
Hi, Lordship.
Please, Lordship. Lordship, I beg to mention item 20, Lordship. So this matter can come after 2 weeks, Lordship.
20?
20, Lordship. I've informed the other respondents.
No objections, Lordship.
Yes.
Duly obliged.
Yes. Yes.
No objection.
For 2 weeks time, Lordship.
Yes. Why?
Lordship, and item 28 as well, Lordship. Item 28.
Yes.
Lordship, this matter, the interim order may be continued.
28 interim order, yes.
Objection.
My lord, I beg to mention item number 23, my lord.
Why?
After 2 weeks, my lord. After 2 weeks,
Balbinder Singh?
my lord.
Yes, Dr. Mozika? Yes. No objection?
After
2 weeks.
Supposed to bring on record some survey report or something?
I've done that.
Okay. Yes, yes.
Please,
Yes,
Your
MS
Lordship.
Rahman.
Lordship, I beg to mention item number 25, Your Lordship.
25, Lordship. Here today I do not have any objection because there is some urgency, because there is an stage operating, Lordship. Because
1 week,
November
yeah.
the election was held and the result has already been declared, but the court has stayed the approval, Lordship. Now lasers are suffering, Lordship, because
1 week, 1 week.
One Lordship. Interim order may continue, Lordship.
Who's your Sasan?
Has said, Lordship.
1 week, yes. Interim order continued.
25 and 26 are connected matter, Your Lordship. 25 and 26.
26 after 1 week.
After 1 week. Interim order may continue, Your Lordship. Similar play for item number 31, Your Lordship.
31 here I am for the private
Yeah,
respondent.
objection.
No, Lordship. Private respondent, Lordship.
Now, what about state respondent? Mr. Khawana.
Objections, Lordship.
Yes, 2 weeks, yes.
2 weeks, Your Lordship. Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 22, Lordship. Due to personal difficulties, Lordship, after 2 weeks, Lordship.
Yes. Yes.
Highly please.
May I please, Lordship. Lordship, may I beg item number 27, Your Lordship. It's a joint request, Lordship.
Let this matter come after 2 weeks, Your Lordship.
Why? What happened? Is it supposed to be settled, correct?
No, Your Lordship. Actually, title suit is still pending, which is in the
order
last.
supposed to be passed?
Not yet.
I have not received any instruction, Your Lordship.
European instruction last time, where was non-cloud?
He is not keeping well, Your Lordship, Mr.
He's not well?
He's not well. He's not keeping well.
Someone's phone's ringing. You don't stop ringing, be confiscated. Yes.
All right.
Or 2 weeks, yes.
Your Lordship, I beg to mention item number 24. Your Lordship, let this matter come out after 2 weeks, Your Lordship.
No objection, Your Lordship.
Okay, yes. Yes.
Supplementary list item number 1.
Please, Lordship. Lordship, in this petition, Lordship, the petitioner, she is an in-service teacher of Tagore Memorial School in Rinja, Lordship. She has been in service, Lordship, since the year 2004. Now, what had happened, Lordship, in the year 2014, after she had already completed about 10 years of service in that same school, there was an advertisement floated, Lordship. There was an advertisement floated by the managing committee for appointment in the assistant sanction post in view of a certain person who was supposed to retire. Now, Lordship, the petitioner applied for that advertisement and participated in the selection process. And amongst other candidates, 14, she was selected at merit list 1 and appointment order was issued. Thereafter, Lordship,
against the sanction post.
In the sanction post. Thereafter, Lordship, what happened is that the approval was not being granted or rather it was refused, saying that at the time of the advertisement the petitioner was overage by a month or so, Lordship. But thereafter the petitioner had made several representations, saying that at that point of time various overage teachers were also approved, and this was a discriminatory treatment, and moreover she was in 10 years of in-service, so that ought to have been considered. In any event, Lordship, being aggrieved with the non-approval or the rejection of the approval, she had filed a writ petition, and initially the writ petition was allowed. In 2016 a writ petition was filed. Writ petition came to be allowed by the learned single judge, and Lordship, thereafter an approval order was passed by the government in compliance with the direction of the learned single judge. Thereafter, Lordship, what happened is that the candidate who came second in that selection process, she filed a writ appeal, saying that she was never heard at the time of adjudication of the writ petition, and that she was not overage, the petitioner was overage, so that is why she should have been appointed. Writ appeal, Lordship, was disposed of with the direction to, the matter was remanded back for reconsideration after impleadment of the respondent. Again, Lordship, the learned single judge passed the judgment.
They remanded back to single judge.
Single judge.
Then what happened?
In 2020, Lordship, the judgment was passed by the learned single judge, where it was again approved. It was again in favor of the petitioner.
So check it history. Then what happened?
Lordship, thereafter, yet again the respondent, the private respondent, being aggrieved, she filed a second writ appeal, and that came to be disposed of, Lordship, in the year 2022, wherein, Lordship, the Honorable Division Bench, Honorable Chief Justice Banerjee, had set aside the approval of the petitioner, saying that the age limit has to be strictly followed and it cannot be relaxed. But there was no direction to appoint the respondent or otherwise.
But isn't that a consequential event?
No, Lordship, what I am saying is that thereafter SLP was carried, it was pending for a long time. In the meantime, Lordship, without any fresh advertisement or without any fresh recruitment process, taking into account that 2014 merit list, in 2022, while the SLP was still pending, the managing committee issued an appointment letter to the private respondent.
What do you want now?
I am praying, Lordship, that they should have gone for a fresh recruitment.
Now what do you want? Why fresh recruitment? If is the subject of its consequential orders, is consequent to the orders of this court.
No, there was no such direction.
You are nowhere in the picture. If the division bench order said that cut-off date or whatever the age has to be maintained, that means you're out.
No,
then even SLP got dismissed.
Here, what is crucial, Lordship, is that my in-service, that I was 10 years in service, that
doesn't matter.
was never,
a dog man,
and I was very much eligible as per the advertisement. Now there was some letter.
No, but then if it has been held by division bench that you are overaged.
No, that is not what they have held, Lordship. They have simply.
And then, if the authorities, the respondents are to maintain the age,
Lordship, yes,
a consideration that at this certain age that you are eligible, then Lordship, where are you?
No, why I am aggrieved, Lordship, is the first thing is I was in service for 10 years at that point of time.
That's a different matter altogether. But from this proceedings, you can't derive any benefit.
No, here my prayer is,
fresh consideration on other circumstances.
Here my prayer is, Lordship, that as per the prevailing now also, there is now even as per the RTE norms now and the notifications of the government,
you are overaged.
Relaxation for in-service teachers is there, Lordship.
So how then you're finding a review of the division bench order?
No, I am saying is that when the division bench set aside the entire process, they did not give any direction for appointment of the private respondent.
Well, that's your case,
Lordship, and so now they should have.
Yes, there comes the issue notice. Response number.
Respondents.
I'll take steps
1 to 4, my lord.
MSNG Shilla so accepts this 1 to 4. Notice to go to parent respondents
5 and 6.
5 and 6 within 3 days. This after 3 weeks.
Obliged.
Much obliged, Lordship.
Item number 2.
May I please, Lordship? Lordship, in this matter, the petitioner is a businessman engaged in.
A businessman?
Yes, Lordship. Engaged in extraction of boulder stones to be converted to a parking lot in Ribhoi district, and he had leased land measuring an area of 1.8 hectares at Jirang Sameachip on Joshri for 30 years, Lordship. And the same executed a lease deed dated 28/09/2023, annexure 1, page 13, Your Lordship. Your Lordship, after executing the lease deed,
Just come to your synopsis on the second page, second paragraph. Where's your synopsis? See your synopsis. Now read your synopsis. Second paragraph in page 2. Where's synopsis? Read your synopsis, page 2. Since as on 1/20 till so and so, date of absorption on their cadre. What is
I
this?
made mistake.
What is this? This cut pasting from another petition.
No, Your Lordship.
You see the boulder.
Yes, Your Lordship.
He's a.
Yes, Your Lordship.
How is he in the Principal Accountant General Office?
Your Lordship. I may be allowed to correct that, Your
You
Lordship.
corrected. You see, you cut pasting. You see, I know
Your
you cut
Lordship.
pasted from somebody petition.
Your Lordship.
It makes no sense.
Your
Suddenly,
Lordship.
since so and so, he's been absorbed into All India cadre.
Lordship, I have corrected the other copies that must. Wrong copy, Lordship.
Yes, MSEB Pasa is allowed to correct the defects in the petition in the course of the day. You be very careful.
Lordship.
Item number 3.
Punishable, Lordship.
Yes.
Yes, may please, Your Lordship. Your Lordship, in the first round of litigation, Your Lordship, the petitioner has approached this cause being aggrieved by the non-regularization and non-payment of salary, Your Lordship. And during the pendency of the petition, Your Lordship, the government of Meghalaya had issued one order, Your Lordship, stating that those employees who are unregularized, Your Lordship, appointed after 2007 will be considered, Your Lordship, and status quo may be maintained, Your Lordship. And at the same time, the state respondent, Your Lordship, had informed this court that they are in the process of creating supernumerary posts, Your Lordship, and the salary also will be paid till then. And accordingly, this court dispose of that repetition, Your Lordship, which is that order which is in Annexure 15, Your Lordship.
Page
15, Annexure 15.
Page. Annexure 15, page
41,
Page
Lordship.
41.
41, Your Lordship.
Yeah.
And after that, Your Lordship, the state respondent did not do anything, Your Lordship, after the lapse of 1 year, which compelled the petitioner to once again.
Suppose the 1 to 5 years.
Yes, which once again compelled the petitioner to approach this honorable court by contempt petition, Your Lordship. And during the contempt petition, Your Lordship, during the pendency of the contempt, Your Lordship, the respondent had informed this court, Your Lordship, that on 9 June, which is in page 44, Your Lordship, that on 9 June 2025, the government had proved the creation of supernumerary posts for the petitioner, Your Lordship. And also the portion of the salary has been released to the petitioner. And that contempt petition also has been closed, Your Lordship.
Did he get the salary?
Yes, salary was get, Your Lordship.
Up to 31,825.
Yes, Your Lordship. No, Your Lordship. Oh, yes, Your Lordship. Till,
yes or no?
Yes, Your Lordship. But prior to that, Your Lordship, she did not receive, Your Lordship, because there are two parts, Your Lordship.
Yes, Mr. Khan, what is this? You have not implemented orders of the court.
No, Your Lordship. Then after that, Your Lordship, the petitioner came to learn, Your Lordship, that there is Kalasi post, Your Lordship, in the department, Your Lordship.
Oh, but in the earlier petition, you had come only to be paid for the period you served, correct?
Yes, Your Lordship.
And for
regularization, Your Lordship.
For that period, you've been paid.
Yes, Your Lordship.
And now you're coming for regularization.
No, Your Lordship.
You're out of service now.
Now I'm out of service, because after this contemplation, the respondent had issued one termination order, Your Lordship, to the respondent.
Okay, yes, no, I see this order now.
Yes, sir.
Yes, however, so and so the council petition submitted that the aspect regularization has not yet been considered by respondents. So issue notice, Mr. Farana.
Your Lordship, I have also filed this case, Your Lordship, because now they are planning to fill up that Kalasi post.
You can't. You have what
and
right
also,
you
Your
have
Lordship,
to.
And also, Your Lordship, this termination order, Your Lordship.
Yes, yes.
This termination order is again their own order, Your Lordship, which is that.
It's only till 31/8/25, correct?
Yes, sir.
Then that's the duration of your service.
Your Lordship, when there is a post, Your Lordship, because as per the government of India,
because there's a post doesn't mean that you have a right to it.
No, but they have created supernumerary post. Supernumerary post means
supernumerary post will end with the duration of your service.
Yes, Your Lordship, but it is abolished only till he is absorbed in a regular post, Your Lordship. That means that, Your Lordship, supplementary post.
May I please, Lordship?
So the petitioner had high hope that the collaborative post is there. She can be accommodated there, but unfortunately.
Now you got a salary with effect 5/5/23 to 25.
Yes, Your Lordship.
Okay, very good.
Lordship, one more point to be.
And Your Lordship, the termination.
Because this post, the existing Khalasi post is not your post.
Yes, Your Lordship.
Then,
but it is a regular post, Your Lordship.
Regular post, but can you claim right? Have you bought that post? It's not a property.
But as per the government of India rules, Your Lordship, for supplementary post, it means that, Your Lordship, when there is
yes.
Lordship, petitioner out here has just challenged the termination order and but then he has not
made any prayer for regularization against the vacant post.
Prayers are page 13, Lordship. Mary, Lordship.
Direct us to a point. We can't direct to a point. Yes.
Lordship, the petitioner out here has just challenged the order dated 13/8/24 or 25, Lordship, and 29/8/25.
At page?
This is at page number, Lordship, page number 47.
Yes.
This is regarding the termination of the supernumerary post, Lordship.
Yes. What was the news? The petition issue notice page Karana. This landed additional senior government advocate.
Lordship. Additional senior Lordship.
All the respondents for the notice called for. Yes, with 2 weeks for instructions. Yes.
My interim order may be passed.
Interim order.
We just write that
Lordship, as of now, there's a new SOP OM which has come up with regards to SOP for regards to the post, Lordship. So
I'll just pray that this impunity should not be effected during the pendency
has accepted that.
During the pendency of this petition, Your Lordship.
Lordship, he has accepted that,
completely out of
yes.
Lordship. Now the petitioner is completely out of the service because of this termination.
Come back instructions. Yes.
Lordship.
Item number 4.
How about you?
What is this?
Here in this case, Lordship, I have challenged the order of appointment of the fair price of dealer of the respondent, Lordship. My Lord
Number
may,
6.
yes, my Lord may recollect, Lordship, based
This
on
PDS matters.
yes, Lordship, based on the inquiry report, Lordship, 10 fair price shop license for 10 villages were cancelled, Lordship.
It's a fresh matter.
Yes, Lordship. Now 6 that agree that dealer has approached this honorable court challenging the order of termination. Now with regard to the 6, no fresh appointment has been issued, Lordship. Now so far as other 4 is concerned, Lordship, now fresh appointment has been issued, Lordship. I am only for here, my Lord, only one. My Lord will see the appointment order, Lordship. That is at page 21.
Lordship, may have these matters on the 27, Lordship. Connected matters are listed on 27,
different
Lordship.
matter. Why I am, Lordship, the license was given to the self-help group, Lordship. It is not a registered body, and it is not.
Is it a temporary arrangement or is it
My temporary arrangement is already there, but it is a
yes.
fresh appointment, Lordship. No advertisement, no inquiry, Lordship. Moreover, he is not a resident.
Yes, heard Mr. Essential and Counsel of the Petitioner issue notice. The Corona is present except we have all respondents. Not respondent 1 to 5.
1 to 5, Lordship.
Notice issue respond number 6. Yes. Just after 2 weeks.
My Lord, at least status because that vigilance committee is already in existence, Lordship.
Lordship,
No status, if they already appointed, no question of status quo.
The vigilance committee there is
Just on 27th with other matters.
Much obliged.
Daily list, item number 1.
Where's the petitioner?
Admission hearing. But petitioner is not here.
None appears as petitioner. Just after 1 week, yes.
Item number 2.
Record that immediately. Yes. Where's the affidavit? Where's the affidavit? Where's the affidavit? Why? You already given them enough time, I think. Yes.
Did appearance on the last day.
Mr. Pierre Pasquet, counsel appearance, counsel on behalf of the priest was allowed for a 2 weeks time for affidavit. You have filed yours?
Yes.
Yes, list that after answer.
Item number 3.
Give me the full handover. May it please his lordship. Please. Good master. Give me the repetition.
Yes.
May it please his
You
lordship.
want to copy to Mr. Thapa?
Lordship, we have here.
Second
All the
report.
parties have been in
Second inquiry report. In fact, my lord, in the second report, my lord, they've given a clean sheet to everybody.
Even to you?
Not to me, my lord. In fact, there's nothing against me. But insofar as the first report is concerned, my lord, the second inquiry report is completely contrary to what was submitted in the first report.
Then you file your objections to this.
My lord, I will file my objection. My lord, kindly.
If it's
lordship, if lordship
contradicts early report, then
they've
there's
undone the
something
first report, my lord, in totality.
lordship, the main prayer in the writ petition is just to conduct an inquiry. If
whatever
lordship
it is, Mr. Shulai, we can understand if only one inquiry. Now you went into, you said that we need proper, more detailed scrutiny. Sir, of court.
Lordship, a second inquiry has been conducted. Your lordship, there is.
It's a further up.
Today, the second inquiry report dated.
This is
8th of August, my lord, the report.
This is 20 July, your lordship.
The inquiry report.
Lordship, yes.
Yes. No. This is the
Lordship,
order.
can you have kindly turn to the next page, your lordship? Inquiry
18
report.
and 19 August. On the 18 and 19 August, inquiry was conducted. See, order. This is the order for
Lordship,
18 and 19 August.
the inquiry
Yes,
was conducted on 18 and 19, your lordship.
A copy of the report of the inquiry conducted on 18-19th of August 2025 has been submitted before this court. Ms. S. Thapa, counsel the petitioner, submits an unperusal of the same. The second report contradicts the first inquiry report. The pre-response allowed 2 weeks time to file objections to the same. File the objections. The report is taken on board and made part of the record.
Next item also same, your lordship.
Item number 5.
Apply, your lordship.
Please, Your Lordship. Your Lordship, I'll be requiring some more time to file my rejoinder, Your Lordship.
What about number 1?
I've already filed.
Is appearing Mr.
Chaudhary, my lord. Respondent number 2, my lord.
You have to file. You have filed affidavit. It's already been filed.
We have filed, my lord. Respondent number 2 has filed.
Why you not filed rejoinder till now?
Lordship,
It's the third time you're asking, or fourth time?
For the respondent one, we just received on the last date, Your Lordship. So it's ready, Your Lordship, but the deponent is not in. He's traveling, Your Lordship, at the moment.
Yes. The pressure praise funds allowed 2 weeks for time for the rejoinder. Yes. Just on so.
I'll apply.
Item number 6.
May it please, Your Lordship. Your Lordship, we are praying for some time, Your Lordship, to file our affidavit.
What is the order violated? It's a pension matter.
Pending bill, Your Lordship.
When are you going to file affidavit?
Week's time, Your Lordship, may be given.
Ms. M.S. Ilinga for the respondent. They respond to a week's further time to file affidavits. This file the affidavit just after 1 week.
Much obliged, Lordship.
Item 7.
Lordship, all the respondents have filed affidavit, Your Lordships. I'm praying for time to file my rejoinder.
4 and 5 is whom? You are 4 and 5.
No, I am for the 6, Lordship.
Who's 4 and 5?
Lordship, I am for respondent number 7.
Oh, HDFC. Who's HDFC?
Lordship, Mr. Marpan is appearing for SDFC.
You all filed. Reserve Bank's filed.
Yes,
Yes, Mr. Pasanthi submits that he has the receipt of all the affidavits filed by the respondents. He prays 1 or 2 weeks time for rejoinder if necessary. Yes.
My lord, I am appearing for respondent 6 minutes.
Yes, we record your presence.
Oh,
My lord. Obliged.
Item number 8.
Lordship, I'm praying for 3 weeks to obtain instructions and file an affidavit.
What instructions?
This is regarding release of this backlog of salaries. I believe it's under process, under consideration.
Backlog over salary.
District Council, Lordship.
The government's offering, but they are not accepting.
Lordship is. And only thing I want to point out, Lordship, that here the petitioner has resigned in the month of February. Sanction was given in the month of June itself. At least they should have made a representation before approaching, Lordship.
They came straight to court.
Lordship is. And that too in July when they are aware that the situation is.
You file in 3 weeks. Prayer allowed.
Obliged.
Yes, sir. After.
Obliged.
Item number 9.
May it please your lordship. Lordship, this is a...
Yes,
carry on.
My lord, we need to file the rejoinder, my lord, in this matter.
Whom?
For the petitioner.
For your number 4.
I'm for number 1, 2 and 4.
I'm for respondent 3, Lordship. To file, Your Lordship.
Yes. Mr. Samara prays for and allowed to stand for rejoinder. Yes, to the affidavits filed by the respondent number
Respondent number 4 and 5.
4 and 5. 4 and 5.
Oh, sorry.
Lordship, it's 4 and 3. Wait for lordship.
Item number 10.
Here I pray for time, Lordship. Here I pray for time, Lordship.
What's the matter about?
This matter was detached, Your Honor, from the previous
What is the other batch of matters?
That is at disposal, Lordship. That matter what happened, all the petitioners were regularized and they were asking for the ACPS, Lordship. Here the petitioner is yet to be regularized, Lordship. The instruction I am yet to receive the final instruction.
SCA prays for the out for it to stand for affidavit. Just after also.
2 weeks, Lordship. Must.
11.
May please, Your Lordship. Lordship, I'm entering appearance on behalf of respondent number 5, 6 and 7.
Very good. Have you filed affidavit?
Yes, I filed affidavit.
Yes?
Yeah, filed affidavit, Your Lordship.
In the course of the day?
No, they already filed, Lordship.
Already filed, okay.
Yes, Lordship.
MS Emir Rahman has entered appearance today on behalf of the respondents 5, 6 and 7. And as such, services complete in all the respondents. She prays for and allowed.
2 weeks time, Your
Kind
Lordship.
of affidavit stop. On behalf of someone 4, the app is already on record. Just after 2 weeks, yes.
12.
May please, Your Lordship. Lordship, we are seeking 2 weeks time allowed to file affidavit.
What's the matter about?
Lordship, this is an application filed by a trade unionist, Lordship.
Trade union is?
Yes.
Your Lordship.
For Provident Fund, Lordship.
Yes, as prayed for the 2 weeks affidavits by the respondents.
For respondent number 6.
You're filing affidavit also?
2 week time.
13.
Much obliged, Lordship.
Respondent number 4
Yes.
is seeking some
Where's the
kind of
petitioner?
right to counter affidavit.
Yes, state lordship will need some time, your lordship.
So you are for 1, 2, 3 and 4.
Lordship,
Yes.
yes. 1,
For
2,
the 2
3,
weeks time as prayed by Mr. Andy Shulai for 1, 2, 3. Ms. E. Sema for 4.
They'll come after 3 weeks, your lordship. 3 weeks.
2 weeks.
Lordship,
14.
14 is also same.
Same respondent?
Correct.
Yes. What's the matter regarding pollution?
No, your lordship, regarding that mining there in the Riboyas Bay, taken up in the Smukut today, your lordship. that matter.
Oh, yes.
15.
May please, Your Lordship.
Filed affidavit today.
Lordship, I've received the affidavit on behalf of the respondent union. We've also served copies on the Union Grants Commission, Lordship.
University Grants Commission.
Lordship, sorry.
Yes.
Lordship, I am praying for some time to just go through the contents.
You already appeared, I don't know, it's the first time.
It's their first appearance.
Yes, record MSS Langstay is at third appearance today on behalf of respondent number.
Respondent 2, Lordship. Lordship, there is a slight confusion with the order of Lordship of the parties. In the cause title, Lordship of the writ petition, UGC is respondent number 2.
But
in the portal, Lordship, they've been registered as respondent 4.
So how do you correct that? Registry, you make necessary corrections of the respondents. Huh? Yes, it is.
UGC, I don't think they have any say on resolution policy.
Anyway, it doesn't matter, whatever it is. But there's no policy of government of India for transgender.
And UGC is not
a central government institution. Yes. Anyway, MS Langstay is entered. I won't say respondent name on behalf of the University Grants Commission. No such notice complete all respondents.
Lordships.
Yes, it is Mr. Next paragraph, Dr. N. Muzika. DSJ also submitted the affidavit on behalf of the union. Has since been filed. Stop. MS D. Cruz placed for the loud.
Lordship, a week's time.
2 weeks time to peruse the same to file rejoinder if necessary.
Lordship.
Just accordingly.
16.
Lordship, I will be allowed 1 week's time to file my affidavit.
But you already paid. When was the matter filed? What's the matter about?
This recently, this is regarding salary, Your Lordship. These petitioner who's a direct who claims that he is aggrieved by the ad hoc employees getting more than him.
Allowed for affidavit.
17.
Obliged.
Whose is this?
Let's die.
You understand?
Well,
yes, we just.
Well, I appear for 2 and 3. Here, there is. I'm instructed. There's a little difficulty. The orders were not uploaded apparently. So we've not been able to seek instructions.
The orders are from the court.
Issue orders or not.
The notice orders, were not uploaded apparently.
Meaning?
They're not there in the website.
Well,
we could not send for parawise reply.
Notice orders?
Well, it's the order by which my lords have issued notice. That's apparently
very serious because we upload all the orders are uploaded every day.
We'll just cross check again. I'm instructed by my learned friend. Should not be the issue.
No.
It's not there.
We're very particular about that.
But we'll double check today. But it was not there. Since last night, it was not there.
When was it last listed?
2012.
Even after uploading, you are aware.
We don't have the order.
We list it tomorrow.
So we'll verify,
Yes. We just break.
Lords would sit again at 2.
I suppose. Yes.
Please, Your Lordship. So I have instructions to withdraw this matter with liberty to file afresh.
Yeah. What happened?
Well, this is that matter which had travelled right up to the apex court. Well, there's no objection insofar as the withdrawal part of it is concerned. Liberty, there's no question.
We had agreed on the last occasion.
No,
this was discussed, in fact.
Well, I'm not conceding to the liberty part of it because the only reason is they are otherwise injuncted by the Bombay High Court, which has now been confirmed by the Honorable Supreme Court, from introducing their products into Meghalaya. So any liberty granted by this Honorable Court, would then not be in consonance. My humble submission would not be in consonance with the orders of the Honorable Supreme Court.
Then the matter will require to be heard on this point, whether I'm entitled to liberty or not.
But liberty, you think if this, will there any fresh cause of action arise? If the matter is closed, if the SLP is dismissed,
Lordship.
Then if this subject, if this particular issue is closed with regard to registration of the brand Meghalaya, then what other recourse you have?
As I was saying on the last occasion, registration of the excise label is one part of it and introduction is a different part of it. For whatever reasons, they've decided not to pursue this matter, but if your Lordships recall on the last date I said, we would like to argue on this particular point. Now they've taken a decision not to pursue this writ petition at the moment.
Notwithstanding the orders of the Honorable Supreme Court, he prays we allowed to argue on the question of application registration of the brand.
Yes, this is what I'd argue on the last date. So we are just praying for liberty to withdraw it. We want to withdraw it with liberty to file a fresh matter in case the need arises. I don't think they're prejudiced in any way.
No, but the issue is that it should not be interpreted.
What your objection?
No, it should not be interpreted as in a manner, that my lords have granted them liberty to approach because just two parts of this orders, if I may just be permitted to point out, if my lords kindly have the orders of the Honorable Bombay High Court, it's part of the record. Let's have it.
Which page?
It's internal page 75. With regard to balance of convenience, the page starts with balance of convenience.
Yes.
It's para 86, if my lords can have a look.
75.
Internal page 75, it's down below. In the bottom, it's there. Page 75 of 83. If my lords have a look.
Oh, internal page 75 of the judgment.
My lords.
Doesn't seem to be internal page. Running page, internal page.
If my lords have this copy, it's the running page.
Oh, this. Okay, sorry.
Para 86.
Para 86. Okay. Even after rejection?
Even after rejection of his prayer for temporary injunction, UTO, that's my learned friend, client, was free to manufacture and sell its own products in India as no injunction operated against it. UTO and ABD were granted leave to apply for introduction of the products in India by order dated 10 September 14. However, after rejection of its prayer for temporary injunction on 22nd December 2011, UTO did not make any attempts to introduce its products in India for a considerable period of time. After failing to secure injunction against Tilaknagar, UTO apparently transferred 50% ownership in the markets in favor of ABD sometime in 2014. Though this court granted leave to UTO and ABD to seek permission of this court for introduction of the products in India by order dated 10 September 14, neither UTO nor ABD filed such application for introduction of products for the next 9 long years. Such application was filed by ABD for the first time in 2023. All these factors would clearly go against UTO and ABD while considering the balance of convenience. And if my lords kindly have a look at para 91.
Yes.
One mark, one source and one proprietor is settled principle of law aimed at achieving the public policy of avoiding confusion amongst the consumers. The net result of the second impugned order is that ABD will introduce the same alcoholic product under the brand name Mansion House in the state of West Bengal. Since there is no injunction against UTO and ABD, they will introduce the products under the same marks all over India, as they need not seek leave of the court on account of dismissal of Tilaknagar's notice of motion. Soon all the states in India will see sale of some alcoholic products under the same trade names of Mansion House and Savoy Club, of Tilaknagar and UTO ABD. This would create utter confusion in the minds of the consumers who have been purchasing products of only Tilaknagar in India since 1987 in the absence of a single bottle being made available for sale by UTO in India. Now, in view of this, Millets, thereafter the final directions come at page 83.
Conclusion.
Millets. I'll read the conclusion as well, Millets. The conspectus of the above discussion is the first impugned order dated 22nd December 2011 deserves to be upheld, since we have held that the first impugned order did not accept UTO's claim of reversion of title, and findings of reversion of title in favor of UTO recorded in the second impugned order also needs to be aligned with the findings in the first impugned order. Also, the resultant status in the Indian market prevailing for the last 14 years after passing of the first impugned order need not be disturbed and needs to be preserved till the suit is decided.
You're owner of the brand.
My lord.
Okay.
So thereafter, my lords, in that view, if my lords, para H3, if my lords kindly have a look at, UTO and ABD shall continue the current status of non-introduction of the products in India under the impugned marks Mansion House and Savoy Club till decision of the suit. Now, this part of the order, my lords, if my lords also kindly have a look at the orders passed by the Honorable Supreme Court. What is the order of Supreme Court? Now, the Honorable Supreme Court says, my lords, if my lords have the orders of Para 2, if my lords have a look at it, we find that the impugned order is by way of an interim arrangement which has been passed by the division bench of the High Court. The suit and the counterclaim are still pending and at large. However, we find, having regard to the issues which arise in the special leave petitions as well as in the suit and counterclaim, the concerned trial court shall conclude the trial of the suit within a period of 6 months from the next date of hearing before the trial court. It is needless to observe that the respective parties and the counsel shall cooperate. I'll skip this. That paragraph, we also say that any observation which has been made in the impugned order is limited for the purposes of disposing of the appeal by the division bench of the High Court, and the same shall not in any way influence the concerned trial court. Now, in essence, the orders passed by the Honorable Bombay High Court, in appeal have been upheld. Now, under which, they are injuncted from introducing any product. Now, if grant any liberty to them, that, in my humble submission, would not be in conformity with the orders passed by the division bench as well as by the Honorable Supreme Court.
We've injuncted for till the suit is.
No, so 6 months.
Just a moment. What I'm trying to get at is this.
How do you seek differential registration and introduction?
That was our core contention before your lordship. So what my lords will just see that the direction of the Honorable Bombay High Court now stand merged by the order of the Honorable Supreme Court.
Okay.
Please see this particular paragraph at the third page.
Or the
third paragraph in the third page.
We also say.
We also say.
We also say, yes,
that the observations, my lord, the observations which have been made in the impugned order is limited for the purpose of disposing of the appeal by the division bench of the Honorable High Court, and the same shall not in any way influence the concerned trial court.
Right.
These are merely observations, and the Honorable Supreme Court has directed
what
Bombay High Court.
By not being influenced means on the merits.
Correct. On the merits.
Now, the only thing is that they look at the balance of convenience,
Lordship,
if I understand the order correctly.
Lordship.
And from a Fasai case, whatever you have.
My lord.
The thing is that you say, okay, fine, for the time being, the order is upheld.
Lordship.
6 months' time that the suit get over.
Correct.
And then finally
So that is exactly what I'm saying. A new cause of action may arise.
Yes,
They
so
will
then-
take the plea that my writ petition is barred. Now I did not take any liberty. That's all I'm saying.
So
Liberty only for the limited purpose.
After the suit is over, then
Precisely. That's all.
If they succeed in the suit, everything opens up for them.
Precisely. That's what I'm saying. Liberty for that purpose.
We'll record the order then. But Mr. S. and Leonard, counsel for the petitioner, who prays that he may be allowed to withdraw the instant application. However, liberty to file afresh, if so advised of. Next paragraph. Mr. K. Police and counsel, though not objecting to the prayer for withdrawal, however, has raised serious objections with regard to the prayer for liberty. They submitted that the order of the Bombay High Court passed in the injunction matter dated.
This order is dated 16 July 2025.
16 July 2025 has clearly ordered that both the petitioner and the respondent shall continue the current status of non-introduction of their products in India under the impugned marks, Mansion House and Savoy Club till decision of the suit. He further submits that the matter wasn't carried to the Supreme Court, wherein the order vision bench was upheld. He therefore contends that any liberty which may be granted will run against the orders passed by the Bombay High Court, Vision bench, as well as the Supreme Court. It's a Mr. SN in reply has submitted that it is a fact that the injunction order has been passed, wherein directions as submitted by the Senior Counsel are in operation. However, submits that as the suit has been directed to be disposed of within
6 months.
6 months. 6 months by the Supreme Court. In the event that fresh cause of action arises thereafter, the petitioner may be given liberty to seek legal remedy, appropriate remedy.
That I cannot object to in any case.
Having considered submissions made by the council parties, on the examination of the order passed by the division bench of the Bombay High Court in the injunction matter, and also the order of the Supreme Court in the special leave petition, the withdrawal of the writ petitions allowed, with liberty granted only if a fresh cause of action arises in the event the petitioners are aggrieved after the suit has been disposed of.
State respondents.
Matters are close disposal of the court.
1, 2, and 3.
Was it accordingly?
Highly obliged.
That should serve its purpose. Yes.
That was what was agreed on the last occasion.
No, that I cannot object to, Melissa. If they succeed in the suit, Melissa will come.
Is why they were objecting to this in the first place. Obliged.
So we can do this on some other day, Melissa. Need a little bit of.
Yes, Mr. Pandey. He's seeking some accommodation. Absolutely.
No objection. No.
After 2 weeks. Yes. On the request of counsel with the parties, after 2 weeks. Yes. Highly obliged.
Obliged.
My Lord, this is that land acquisition matter. My Lord has disposed of a similarly situated matter by giving the parties the liberty to approach to file a representation before the competent authority, and will dispose it of within 2 months by directing the parties to the competent civil court.
So what do you want here?
My Lord, same relief, my Lord, because admittedly, my Lord, the issue my Lord, the disputed questions of facts are involved here. So
Petitioners were illegal occupants of the reserved forest. Lord.
That was as a.
That is the designated forest, and we have also made inquiries and.
Have you filed affidavit?
Yes, Your Lordship. We have filed
their affidavit. My Lord, in the affidavit, they have said that okay, this land falls within the
designated
reserve forest.
That these occupants are illegal occupants, unauthorized occupants.
That is,
and
that
they
is
have
only
no
a
right to
statement,
be there.
There's nothing to indicate
And so
whether
they are
it's
not entitled to any land compensation. Your Lordship.
Whether it is a reserve forest or otherwise, there is nothing to indicate here. There's a statement to that effect.
Inquiry has been made. We have attached the annexures also.
I don't see any inquiry.
When the hearing was done, none of these people came before the hearing committee and produced any documents to establish their right over that place, Your Lordship.
That is not the correct position. In fact,
affidavit is there,
our lands were never surveyed also, my Lord.
It was surveyed, it was...
We have the documents.
No. They have no documents, Your Lordship, to establish their rights that they have.
My Lord, we have been in possession of those lands for fairly very long period of time.
It reminds me of some article I saw the other day about some Africans occupying a certain little forest in Scotland. saying that it was a part of the kingdom 5,000 years ago.
My lord, that possibility also cannot be ruled out, my lord. Probably they migrated from years before the records.
Africans from Scotland Highlands to.
The Scots have done that, my lord. Probably the Africans also. They are nowhere barred.
See, one thing is that public hearing was notice issued, but nobody came. You see, para 7.
Para 7 of their affidavit.
Yes.
They failed to submit any formal written objection within the stipulated period. Public hearing was accordingly conducted.
How many petitioners are here?
My lord, there are about 80. There are 81 petitioners.
As per the office records, Your Lordship, there are only 4 genuine forest villages. We have attached this list also, Your Lordship, at page 21 of our affidavit.
Then we can't issue a similar order, Mr. It's done different footing in this case.
Lord?
It's done different footing than what you're saying.
No, my lord.
It comes under the National Highways Act.
My lord, the earlier order was also under the same act, my lord.
There was no.
No, my lord, we have also filed our rejoinder, Lord. Now,
so according to their records in 2024, there are only 4
genuine forest villages.
My lord, that is. My lord, that is an inquiry which is done by.
That are going to be that are being affected by the proposed diversion of NH 62, Your Lordship.
My lord, in a
so
similar
they were the only ones who were entitled to compensation, Your Lordship.
In a similar case, my lord, which came before my lords. Now, my lord, they came up. It's along the same stretch. They said that they have identified another set of forest dwellers, my lord.
What prevented you from going to Deputy Commissioner when the time the hearing was done and survey was done?
My lord, they had filed a representation. This representation, my lord, is it?
A magisterial inquiry was also held, Your Lordship.
The representation is at Annexure 8.
Even as a September, the Gazette notification issued.
But otherwise, these people will be left remedialess, my lord.
What about page 41?
Not page.
Annexure 6, page 41.
I know this is.
The Deputy Commissioner Revenue has given a report, Your Lordship.
And that is the resolution, no? And page.
No, page 41.
And the inquiry report is at page 45, Your Lordship. A magisterial inquiry was conducted on receiving objections, and this magisterial inquiry report also has come to the same conclusion.
Conclusion. So what remains now? What directions can we give? Is it a question of where It was not all due process. Due process has been followed. Yeah, let's see your petition. What do you base your claims on?
Now, my lord, at para 8 and 9, my lord. Now, my lord, what? Yes, my lord, of my writ petition, lord.
Because the same Nagalpara market, you see.
Yes, my lord.
That what was done, even this inspection. Yes.
Now, my lord, only khas lands were surveyed, my lord. The lands where the dwelling houses of the petitioners, etc., are there. These lands were never surveyed, my lord. Now they filed the affidavit saying that these lands are the properties of the petitioner fall within the reserve forest. That is what they have said in their affidavit. And to substantiate their contention, they have filed an inquiry report, my lord. Now this was an internal inquiry.
At para 8 we have replied to that also, Your Lordship, in our affidavit.
I think you went there, you already made this for the
They have
question
made
not
it,
heard.
is submitted that
You
following the
said-
public hearing
you said that
process.
in para 11 also.
A joint survey of the affected areas were conducted in the presence of officials from the Revenue Department and the Range Forest Office, Dina 2B Range. The lands under
My lord, admittedly,
they fall within the reserve forest.
Admittedly, question of referring the matter back.
My lord, admittedly, my lord, the admitted position in our case is that we have nothing, no documents to show our ownership over the land. But the fact,
forget about ownership,
my lord,
even occupancy,
my lord,
which you allege you're occupying, that's been examined also. The thing is that now you're seeing your shops and all. Now that you see the inquiry report, they've examined that. You see, even for those people who have settlements, they've already been compensated earlier on. So whether it's a case of nowadays, this not saying that they've not taken your whatever your complaints to account. So there are 4 people from what identified. Then the other people who allege they're not even affected by the expansion of the highway, and number 2, those people affected, they've already been compensated.
my lord, these 4 people who have been identified as forest
Forget the
dwellers,
4 people. We're talking about your people only.
my lord. From
They failed to produce any valid documents.
my lord, none
Who
from
was taking a compensation, God knows.
my lord, the thing is here, the only khas lands, my lord, the land belonging to the Nokma has been surveyed, and the compensations have been paid to the respective Nokma. But the people who are residing here, now, my lord, what actually happens in Garo Hills is that the Nokma is the custodian of the land. The Nokma allows the.
He didn't share the money with.
No, no,
that's what
they don't do it because. Well, this is what is happening. Well, this is the ground reality.
This is the same thing has happened. There's one here, Mahindra Marak also. I don't know, but it was withdrawn by the. The same thing is that for acquisition of Nagar town. So the thing is that amounts were paid. People who were whose lands taken over didn't receive. They
will not receive a single pie because
hand from the
yes, my lord,
had already gone
from the acquiring authority, from the acquiring agency,
the Nokmas and to
yes,
certain people who are named there. So that's what happened.
This is what has been consistently happening.
How do you address that thing?
My lord, but that needs to be addressed, my lord. There has to be a remedy.
Ask them to be double compensation. For them, they're tangible authorities and Nokma. He comes forward. For him, you all are there also. He's supposed to be a custodian, look after your well-being. So this is what's happened here also because it was compensated.
And of course, see, the affidavit is silent.
Of, that yes, there has been no survey. Number 1, yes, there has been no.
My lord, there has been no survey, my lord. There has been no survey insofar as our lands are concerned. it has been taken for granted that our land falls within the reserve area and we are not entitled for any compensation of that sort. So we were completely ignored, and then finally
for those people who are affected,
my lord,
and who have come and complained,
my lord,
compensation is already paid.
My lord, but they have not
see the affidavit. Have you filed a journal to this?
Yes, my lord, I filed.
See page 44. Let's see. Inquiry report 45. Sorry. Just now, I just saw just now. I don't know. Where's the affidavit?
My lord, this is the finding with regard to Dynadobi market.
That's Nogalpara only.
Nogalpara.
Nogalpara. Only. This falls in Nogalpara.
Where's the affidavit filed by? Yes. Yes, we see page.
At 45 is the inquiry report.
See, conclusion.
Yes, my lord.
See, based on the findings of inquiry, it's evident that the claim for compensation by shop and building owners from Dynadobi market pertain to land has already been acquired and compensated, as cited by the RO Tribunal, and the Gazette notification. Consequently, no further further regard to claims gone by Nogalpara market, so and so and so. The orders confirm that his owner and accounts have been identified unauthorized forest dwellers.
They are identified as unauthorized forest dwellers.
So, with regard to, and then you come to page 48 also. Genuine, and see 48 also 0.7 HRD's option. Here land question within so and so. Compensation measurement issued and authorized compensation. And next paragraph we mentioned the range forest officer shown the boundaries of forest, also shown the areas where joint forest dwellers are authorized. The areas inhabited by the joint forest dwellers are away from the highway and are affected by widening, except for few of them, and few only 4 of them.
4 of them, your lordship.
Well, that is the internal survey. That is how they have identified. But their entire case is based on the premise that it is a reserve forest. We have filed our rejoinder. My lord, kindly come to the rejoinder, annexure 1 and 2 of the rejoinder. Now, my lord, we can't just they have been identified, declared as independent forest by the GHDC.
2013 was it annexure 1?
My lord, page 11 of my rejoinder.
Yes.
Rejoinder to their affidavit.
This village of Chibrap.
Yes, my lord.
Nogalpara is a market.
My lord, all these areas fall within the Dorocha King.
So this is a notification also. My lord. Someone else's letter must be.
My lord.
Someone else's letter. Where is addressed to you? That how can you connect yourself on this letter?
With this land also, your lordship.
My lord, these lands, my lord,
how
all within this
will
village.
the court go into that? How will we connected?
So, therefore, my lord, I am submitting that of course disputed questions of facts are there, my lord. So it is only the competent civil court which can adjudicate here.
When you withdraw it, you seek alternate remedy.
Yes.
The only thing, my lord. But if your claims are based on, because we're not going to go, see, they already have the materials shown. Red court can go only in the materials. The records are before the court. And as per the record, prima facie, you know very well you don't have a case. So you want to take a chance, you draw it, and then you take your chances, file a suit.
My lord, if my lord will
because you are reducing it to a private law remedy now.
If my lord will take a liberal view of this matter, considering the fact that
how liberal view can we take? Because we are bound by law, Mr.
My lord.
Not by.
I totally understand that. No, my lord. Not by emotion, not by sentiments or other things.
Because what the materials are shown, my lord. See, we counterbalance them, right? So we weigh them. It's a core of equity. So if we have overwhelming materials that show that yes, there has been some lapses in the procedure adopted or somewhere.
Lapses to the
then we will there's no hesitation in the court ordering that, it be re-examined. But in this case, using Danarubi market is there, Novalpara is covered also.
My lord, lapses to the extent
and even
that
the question of forest dwellers has been addressed also.
My lord, lapses to the extent that there is no denying that these lands are going to be acquired, my lord. Now, however, there was no survey, my lord. Our lands were never surveyed.
Joint survey, you written your own application, in your own petition, you said survey.
My lord, in paragraph 8, I have said only khas lands have been surveyed, my lord. The lands which are.
What is khas land?
My lord, khas lands where, where there's proper documentation. Proper documentation in the sense that, my lord, as I have submitted, my lord, these lands in Garo Hills, my lord, the NOCMA is the custodian of the property. Then the NOCMA, in his capacity as the custodian of the property.
If he stays asking, he has no right. He's a community land.
My lord,
it's community land. Then.
My lord, it is a community land. The NOCMA as a custodian holds it for the community.
The NOCMA has to certify you that yes, these people are living here, and where's the certification? Because if you live in Aking, that means you're under NOCMA.
Of course, my lord.
Then,
because
where's that?
The NOCMA is the only authority.
Mr. Gautam.
Yes, my lord.
Looking through, I can't find the link. You understand? That link to it's like the missing link to show your grievance and the thing. That's the thing. To establish your case substantially. I can't find the link.
In that case, if I may make a small prayer, my lord, if my lord will have this matter after 1 week, I'll try to make out a case, my lord.
And especially, like you're right, all disputed facts, where khas land was disputed. But otherwise, I can't find the link between. I can't find the link between the people who are aggrieved.
Otherwise, my lord, will be left remediless, my lord.
The civil court is there, your lordship. If they have a right, they can establish their claim over those properties. Then they can do it.
You have to file your. Yeah, we're not advisory capacity. You are free to seek other remedy.
Let this matter come after a week, my lord. I'll make I'll make a last effort to satisfy
after
my
hearing
lord.
After a week,
Mr. KC
after
Gautam
10
prays
days,
that
your
the matter
lordship.
be taken after 2 weeks.
All right.
Tentative view, you understand?
Yes, my lord.